Good morning, everybody, and welcome to this third webinar in our series on voyage charter topics. As some of you are aware, we've already completed a series on time charter topics, and all of those are available on the Birketts YouTube channel. Now, moving on to our topic today, cargo responsibility and stevedore damaged. Whilst this topic is falling under the voyage charters heading, it's also relevant where voyage charters are incorporated into bills of lading, and we will be doing a webinar series on cargo claims and bills of lading later on. Now, this topic is a particularly relevant one, as a great deal of the disputes that arise under voyage charters and the bills that incorporate voyage charter terms revolve around responsibility for these operations. This is particularly so given that English law treats the relationship between Article 3.2 of the Hague or Hague-Visby rules and Article 3.8 of those rules very differently from some other jurisdictions. As you will hear, just because an English law voyage charter incorporates the Hague or Hague-Visby rules, that's not the end of the story where responsibility for cargo operations and stevedores is concerned. Now, in terms of the structure of the webinar, Alex will speak to you first about responsibility for cargo operations before I move on to talk in more detail about stevedores, with particular focus on the question of stevedore negligence versus incompetence. Now, without further ado, I will hand over to Alex.
Thank you, Sarah. There will normally be a provision in a voyage charter that states whom, as between the owner and the charterer, is responsible for loading and discharge. In the absence of any express provision in the charter party, then at least historically, responsibility for cargo operations depended on the custom of the port where those operations were taking place. In the absence of any settled or established custom of the port, responsibility for cargo operations in terms of both risk and cost passed at the ship's rail. However, this rule seems somewhat more suited to the 19th century, and it is suggested that at least where a vessel is geared, responsibility may pass when the cargo is placed under the ship's hook. Now, before we go on to consider some specific charter party clauses and wordings, I should add that where a charter party contains a clause paramount, the Hague or Hague-Visby rules take effect, and Article 3.2 provides that owners are responsible for loading, stowage and discharge. Article 3.2 provides that, subject to the provisions of Article 4, the carrier shall properly and carefully load, handle, stow, carry, keep, care for, and discharge the goods carried. Could I have the next slide, please? So, just because a given charter party may contain a clause paramount does not necessarily mean that owners will be responsible for cargo operations. It is established law that any express clauses merely transferring responsibility for loading, stowage, and/or discharge of the cargo from owners to charterers are not nullified by Article 3.8 of the Hague or Hague-Visby rules. And there's a line of authorities on that. Neither are clauses describing where delivery shall take place. And Article 3.2 does not compel the ship owner to be responsible for loading and discharge. It simply compels the ship owner to load and discharge properly if he is undertaken to perform those functions. So what English law and Article 3.8 of the Hague-Visby rules do not allow is for charterers to retain responsibility for performing cargo operations whilst transferring the risk or responsibility for the proper performance of those functions to charterers. Could I have the next slide, please? So just to look at some express clauses now. The GENCON 1976 form is a good example to look at because the form is still in common usage, and clause 5 of that form consists of two alternative clauses from which the parties must choose between at the time of contracting. So there are the gross terms and then the F.I.O.S.T alternative. So to deal with the gross terms first, the clause 5 provides the cargo to be brought alongside in such a manner as to enable the vessel to take the goods with her own tackle, charterers to procure and pay for the necessary men on shore or on board the lighters to do the work there, vessel only having cargo on board. If the loading takes place by elevator, cargo to be put free in vessel's holds, owners only paying trimming expenses. And any pieces or packages of cargo over the weight of 2 tons shall be loaded, stowed, discharged by charterers at their risk and expense. The cargo to be received by merchants at their risk and expense alongside the vessel, not beyond the reach of her tackle. So, as you can see from the slide, the clause provides that both receipt of the cargo by owners at the load port and delivery of the cargo by the owners at the disport is to take place alongside the vessel. This means that charterers are obliged to bring the cargo within reach of the ship's tackle and, if necessary, place it on slings or pallets. They must also provide the shoreside labour that is necessary to place the cargo within reach of the ship's tackle. It is then owner's responsibility to actually load the cargo and stow it in the holds. This may be done through the ship's own gear or through the use of shore gear, and owners may choose to employ shore labour, so stevedores, to carry out this work, but would remain responsible for it. Under the same clause, it is owner's responsibility to deliver the cargo by placing it on the quayside. Charterers must then remove it from the ship's tackle and are responsible for all subsequent shoreside operations. You'll also notice that under the clause, the situation is different when loading takes place via an elevator, which would normally be used for a grain cargo. In that case, the charterer is responsible for arranging and paying for the cargo to be delivered to the holds free of expense to owners. However, the clause makes no similar provision for discharge. So the discharge of the grain cargo by spout would be a joint operation. Could I have the next slide, please? So F.I.O.S.T is an acronym for free, in, out, stowed, trimmed, and many charter parties use this acronym, often in the freight clause. However, it was confirmed by the House of Lords in the Jordan II that the use of the acronym will not, without more, transfer responsibility for proper performance of cargo operations to charterers. So, as Lord Justice Tuckey said in that case, the natural meaning of the word free is at no cost, in this case to owners. It is not suggested that it has any wider customary meaning, and appearing as it does in the freight clause, I can see no reason why it should be given any wider meaning in this contract. And that decision, that a clause which transfers the cost of cargo operations to charterers will not, without more, transfer responsibility for performance of those operations, was recently reaffirmed by His Honour Judge Pelling in the Sea Master. So as such, if a clause in a charter party is to have the effect of transferring responsibility for the functions of loading, stowage or discharge to the charterers, it must be in clear terms. So could I have the next slide, please? One printed F.I.O.S.T clause that does appear to be very clear, although there is actually very little case law directly on the clause, is the F.I.O.S.T alternative found at clause 5 of the GENCON. So that clause provides the cargo shall be brought into the holds, loaded, stowed and or trimmed, and taken from the holds and discharged by the charterers or their agents free of any risk, liability and expense whatsoever to the owners. The owners shall provide winches, motive power and winchmen from the crew if requested and permitted. If not, the charterers shall provide and pay for winchmen from shore and or cranes, if any. This provision shall not apply if the vessel is gearless and stated as such in box 15. So in the opinion of the editors of Cook on voyage charters, which was published some time ago in 2014, where the F.I.O.S.T alternative at clause 5 of GENCON 1976 is selected, the owner is under no liability to the charterer for damage caused by carelessness in loading or discharging or by bad stowage, and the charterer is liable to indemnify the owners against liability to a bill of lading holder from any improper performance of those operations. Moreover, since the charterer imposes upon the charterer the obligation to load, stow and discharge the cargo, it also imposes by necessary implication an obligation of the charterer to carry out those operations in a proper and careful manner. So the clause does appear to use very clear language, stating that owners should bear no risk and responsibility whatsoever for cargo operations. Further, no mention is made of the master or his role in the operations. So it follows that the GENCON 1976 F.I.O.S.T alternative is a bad option from a charterer's perspective, and if you are a charterer, you may wish to amend it if you have the bargaining power to do so. Any other clauses, or lots of other clauses, will not be so clear, and therefore careful analysis of the wording used in any loading or discharge provisions must be undertaken. And I'll come on to that in a minute. Just to deal with the words supervision and responsibility, you may find a F.I.O.S.T clause such as the one at clause 5 of GENCON, but with wording added to the effect that loading, stowage or discharge should be carried out at the master's under the master's supervision or responsibility. And in Court Line and Canadian Transport, which is a 1940 case, it was held that the clause providing that cargo operations should be carried out under the master's supervision did not impose a duty on the master to supervise, except possibly where the seaworthiness is concerned. However, owners might have been liable for the consequences of poor stowage if the master intervened and insisted that cargo was stowed in a certain way. However, it has been held that a provision stating that cargo operations shall be carried out under the responsibility of the master would have the effect of transferring liability for the proper performance of the cargo operations back to owners. The next slide, please. So the following are examples of wording in sort of bespoke clauses that have been held by the courts not to transfer responsibility for cargo operations to charterers. So charterers being allowed to appoint a head stevedore at the expense and under the inspection and responsibility of the master for proper stowage, that was held not to transfer responsibility. Cargo on delivery alongside to be received by the master and to be at the vessel's risk. Shipper for the sum of $2 per load to appoint and pay for any stevedore to load the cargo. That also did not transfer risk. Cargo to be loaded, stowed and discharged free of expense to the steamer with use of the steamer's winch or winchman if required, and stevedores to be appointed by the charterers but employed and paid for by the owners at current rate. Although that's a very old case. So next slide, please. The following are examples of words which have been held to transfer responsibility to the charterers for cargo operations. So, and one, that the ship to be stowed by charterer stevedores and at the expense and risk of the vessel. Charterers to provide and pay for a stevedore to do the stowing of the cargo under the supervision of the master. Charterers are to load, stow and trim the cargo at their expense under the supervision of the captain, and cargo to be loaded, discharged, trimmed and stowed free of any expenses to owners. And lastly, shippers, charterers, receivers to put the cargo on board and discharge the cargo free of any expense to the vessel. So in the relatively recent case of the Sea Miror, the court considered clause 5 of the Sino-Comax 90 form, it was common ground that responsibility for stowage was with owners, but there was a dispute as to whether responsibility for loading and discharge operations lay with owners or charterers. The relevant clause provided cargo shall be loaded, trimmed and or stowed at the expenses and risk of the charterers and shippers. Cargo shall be discharged at the expense and risk of receivers, charterers. Stowage shall be under master's direction and responsibility. So cargo interests argued, among other things, that the words "at the risk of" did not impose responsibility for proper performance, particularly as they argued that the clause itself drew a clear distinction between risk and responsibility, and it would be inconsistent for charterers on the one hand to be responsible for loading and discharge, and owners on the other hand to be responsible for stowage. They argued that the meaning of "at the risk" was that charterers were to bear any loss caused by the damage which occurred fortuitously. However, following the Fantasy case, 1991 case, Mr. Justice Flo equated risk with responsibility in holding that the words "at the expense and risk of charterers and shippers" in the case of loading, and "at the risk and at the expense and risk of receivers, charterers" in the case of discharge were sufficiently clear to transfer responsibility for loading and discharge and for any shortcomings in those operations to the charterers and the cargo interests. So could I have the next slide, please? That's just the clause in the Sine-Comax clause in the Sine-Comax 90. As the judge in the Court of Appeal in Jordan 2 expressed, each of the cases that I've just sort of been through very quickly will depend on its own circumstances, and care should therefore be taken when trying to derive any particular rules of construction or interpretation from any of those cases. If I could have the next slide, please. The authors of Voyage Charters at paragraph 14.55 have helpfully set out some useful guides to construction. So number one, as the responsibility for loading and discharging operations within a ship and for stowage are normally with the owner, clear words are needed to transfer responsibility to a charterer. Two, the clause, a clause which confers upon the charterer the right to appoint stevedores does not, without more, transfer to him the responsibility for the acts or omissions. And a clause which makes the charterer responsible for the expense of employing stevedores to perform loading, stowage and discharge does not, without more, transfer responsibility. However, a clause which provides that the charterer shall perform loading, stowage and discharging does transfer responsibility for those operations. So in an almost final note, following the decision in Sea Miror, it seems that clause 5 of the Sine-Comax 90 form is just as bad or nearly as bad for charterers as the F.I.O.S.T alternative in clause in GENCON 1976. If you'd like an example of a printed clause which is better for charterers, please have a look at clause 14 of the Sugar Charter Party 1999, which Sarah will go on to mention. Next slide, please. Just to deal briefly with wet cargoes, a lot of disputes regarding wet cargoes tend to revolve around whether contamination has occurred shoreside or on board. It is almost universally the case under liquid charter parties that the cargo will be at the risk of charterers up until the point when it passes past the vessel's permanent manifold. Clause 10 of ASBATANKVOY provides that pumping in is entirely at the risk and expense of charterers, but this will not absolve the ship owner from liability for loss or contamination to the cargo on board caused by any defect in the vessel. So I'm now going to hand you over to Sarah, who's going to talk more about responsibility for stevedores.
Thank you, Alex. So Alex has spoken to you about responsibility for loading and discharge under a voyage charter, and I'll now move on to look at responsibility for stevedores, and in particular damage caused by stevedores during loading and or discharge. Where loss or damage has been caused by or is attributable to stevedores, there are generally three scenarios to consider. The first is loss or damage to cargo, the second is damage to a vessel, and the third is personal injury. Now, cases involving damage to a vessel and personal injury are beyond the scope of this webinar, which will concentrate on the issues of damage to cargo, which is in any event more commonly encountered. But in brief, however, it's worth noting that a ship owner owes a duty of care to persons coming aboard his vessel, which includes stevedores, and there are many statutory provisions and obligations in place designed to ensure the safety of persons working aboard vessels. This will include ensuring the safety of any vessel equipment used in cargo operations. An owner may find himself on the wrong end of a claim for personal injury to a stevedore if there is any failure on its part to ensure that the vessel is safe for any cargo handling operations performed by stevedores. So what do stevedores actually do? Now, perhaps it's an obvious point, but stevedores are engaged to load and discharge cargo from a vessel. Responsibility for their actions will depend upon on whose behalf they have been employed. This may be a shipper of a cargo, a vessel owner, or a charterer of the vessel. In order to determine on whose behalf the stevedores have been employed, careful analysis of all the relevant contractual documents relating to the carriage of the cargo will be required. Now, this is because in some cases, the issue of who is liable to pay for the consequences of any damage caused by stevedores may be separate from the issue of which party is responsible for appointing or supervising them. Now, as Alex has explained, under English common law, owners are responsible to properly and carefully load, stow, trim, and discharge cargo. Now, I'll describe that collectively as cargo handling operations, and they do so at their own risk and expense. Owners would therefore be responsible under common law for any losses or damage caused by the negligence of stevedores, unless they could prove under normal principles of contract law that any actions of the charterers broke the chain of causation. It's therefore usual for owners to seek to transfer the primary responsibility for cargo handling operations to charterers by the use of express contractual provisions. And as Alex has explained, an example of that would be the GENCON 1994 Clause 5. A consideration which often arises where charterers agree to appoint the stevedores. I'll phrase that again. One consideration which often arises is the situation where charterers agree to appoint the stevedores, and appoint being the key word there. Where such a provision exists, charterers are generally deemed under English law to have an implied responsibility for appointing competent stevedores. And the key cases to look at on this are the Sino, which is from 1972, and the Clipper San Luis from 2000. Now, competent here means that the stevedores must not be incompetent, which is a more pronounced level of bad performance than mere negligence. Now, case law offers very little guidance as to the difference between stevedore incompetence and stevedore negligence. However, key factors to consider include the extent of the loss or damage, the experience of the stevedores, whether there's been any dishonesty or theft, and the methods and equipment used by the stevedores. Now, the effect of this is that where a charterer is responsible for appointing stevedores, but the stevedores are to be considered owners' servants, the owners will be responsible for cargo loss or damage caused by stevedore negligence, but owners will be able to avoid responsibility for cargo loss or damage caused by the more severe stevedore incompetence. Now, on this, it's useful to look at the Sugar Charter Party form, which Alex mentioned, where it states explicitly in the Stevedores F.I.O.S.T clause that stevedores shall be considered as owners' servants. Now, that particular clause was considered in London Arbitration 1301. In London Arbitration 1813, it was decided that cargo interests or charterers are generally considered unable to argue successfully that they are not responsible for the incompetence of stevedores when the stevedores are effectively employed or chosen by the port authority. So what that means is a charterer can't say that because they had no choice, they are not responsible. The rationale here is that cargo interests or charterers have assumed responsibility for such incompetence, regardless of whether they are actually able to select the stevedores in question, simply because they agree to appoint them. The Clipper San Luis sets out that whilst it's appropriate to imply a term to the effect that charterers will appoint reasonably competent stevedores, it's also the case that, and I'm quoting here, neither necessity nor business efficacy justifies imposing a warranty that the stevedores would not be careless. It's also to be noted that this case concerned a time charter, under which the vessel would be required to call at a number of different ports according to the charterer's orders. Now, of course, this isn't the same situation as a voyage charter, under which the owners agree to call at a named port or ports, which brings with them known risks, including the risk of substandard stevedore operations. Now, in the Sino, which dealt with a cargo of bagged cement, the tribunal had held that stevedores were, and I must admit I rather like this quote, clearly the stevedores were not having a good day. So the stevedores were incompetent, inexperienced, too few in number, unequipped with sweepers to clear the escaped cement from the undischarged cargo, supplied with the wrong gear, and allergic to all orders and directions of the master. So on the basis of this finding of fact by the tribunal, which was reached on examination of the evidence, the Court of Appeal held that the charterers had, and perhaps this is unsurprising, breached their implied duty to appoint competent stevedores, and they could not, as a result, rely on a provision in the charter party placing responsibility for stevedore negligence on the ship owners. Now, in short, where charterers have a duty to appoint stevedores, that is a duty to appoint reasonably competent stevedores. If instead they appoint stevedores who are shown by proven facts to be incompetent, the owners may be excused responsibility for damage resulting from that incompetence. The burden of proving that the stevedores were incompetent, rather than simply careless or even dishonest, is on the owners. So that brings to an end the webinar itself, but we'll move on to some questions and answers. Now, a number of you have very kindly submitted questions in advance, which we'll run through first, and then if you've got any other questions, please do submit them and we can read them at the same time and get back to you on those. So one of the questions that was submitted in advance is, where there is clear evidence that stevedores have stolen cargo, and the person refers to rice in West Africa, is that enough to prove incompetence? Now, unfortunately, this is a scenario that I think many of us will have come across on a number of occasions. And as with most things, it will depend on the particular facts of the case. There are actually surprisingly few authorities on the point, but I mentioned London Arbitration 1813, and that suggests that if there is a consistent course of conduct falling below what would be expected, that is likely to be incompetence. I therefore suspect that it may depend on the scale of the problem, and the extent of the theft can also be relevant. It's probably also worth mentioning that incompetence needs to relate to the particular loss. And what I mean by that is, if stevedores are stealing cargo, that loss could well be due to incompetence. But if the same stevedores are also, let's say, dropping cargo overboard, but it's an accident, they're doing the operation properly, they're just dropping some of the cargo in the process, that could be negligence. And the incompetence therefore needs to be causative of the loss in question. Someone's asked about the recourse position on cargo claims. If I understand that correctly, that's been covered in one of our earlier webinars in the Time Charter series. I think it is called Responsibility for Cargo Claims, and that was with Henry Adams and Tom Hodges. That's on our YouTube channel. I think if you just literally put Birketts YouTube into Google, you should find it. But any problems, let us know, and we'll send you a link. Alex, I think this next one that could be a good one for you. The question is, at common law, is an owner or charterer responsible for cargo operations if the contract is silent? Do you mind taking that one?
Of course. So as I said at the beginning of the webinar, every charter party we've ever seen has contained an express clause dealing with responsibility for cargo operations, or a clause paramount. In the absence of that, many of the leading practitioners' texts still refer to responsibility passing at the ship's rail. However, that rule was criticised by Mr. Justice Devlin in Pyrene and Sindia back in the 1950s, and it would seem to us that nowadays it is more likely that responsibility passes when the cargo is placed under the ship's hook, with the effect that the owners would normally be responsible for loading, stowage and discharge.
Thank you, Alex. There's a question which says, what are the rules for damage to containers? If I've understood this correctly, I think we're being asked, what are the rules if a container unit itself gets damaged in the course of loading or discharge? If I've understood that incorrectly, please do let me know, and I'll try again. But if the question is, what happens if a container gets damaged during loading or discharge? Now, it would be relatively unusual for a container to be carried under a voyage charter, but I mean, it does happen. And in those circumstances, the container would generally be considered part of the cargo, and any damage to the container would be treated in the same way as damaged cargo. However, I mean, very often where a container is envisaged that containers will be carried under a voyage charter, you would expect to see a specific term in the charter party dealing with container damage. This person's also added a comment about container demurrage. So container demurrage, as with normal demurrage, if the cause of the delay giving rise to the demurrage is attributable to contractual fault on the part of the carrier, then demurrage shouldn't be payable. I hope I've understood that correctly and answered it as you'd hope. But if not, please do let us know afterwards or in the chat box now, and I'll have a look at that. Alex, there's one here which I think probably fits in with what you've spoken to us about. What is the legal value of instructions given during operations, so I guess during cargo operations?
So I think it would depend upon who is giving the instructions. If we take stowage as an example, a master would have a duty to intervene if the proposed stowage would cause a seaworthiness issue. However, if a master went further than that and made directions in relation to loading or stowing the cargo or discharging, and damage occurred as a result of that intervention, the owners would generally be responsible, though it would depend on the terms of the charter. And I think the authority for that, certainly in respect of the master intervening with stowage, is the Canadian Transport v Court Line, which was a 1940 case.
Thank you, Alex. There's one more that's come through on the questions here. So this is the last one we've got. So if there are any others, please do send them through now. This question says, what happens if the bill contains a paramount clause, not the charter party, but you represent the receiver? So if I've understood this correctly, if you represent the receiver, then you're going to be making a cargo claim under the bill, if that is the scenario. So in that situation, it's immaterial whether it's the bill or the charter that contains the paramount clause, because the rules, the Hague or Hague-Visby rules, whichever is relevant ones in that case, are incorporated into that contract. So I'm hoping that deals with that question. Thank you all very much for your time. As I say, this will be sent to you afterwards, and all of the other webinars are available on the Birketts YouTube channel. So please do feel free to have a look at those at your leisure. Thank you again, and the marketing team will be in touch with you shortly about the next webinar in this series. So thank you all very much.